All right, hello everyone, and welcome to our latest ALTA Insights webinar. I'm Jeremy Yohe, ALTA's Vice President of Communications, and today we've got a real interesting presentation lined up to help you learn how to respond if you're ever served with a subpoena to produce documents to maybe a previous transaction that you've handled. Today's webinar is being recorded. You'll get an email with a link to the recording and a copy of the presentation tomorrow. You can always access all of our webinar recordings at alta.org/webinars. You can also actually download a copy of the presentation right now from the handouts section in the GoToWebinar window pane. Anytime you have a question, submit them in the questions box. We'll hold some time at the end for Q&A. Also need to thank AccuTitle for sponsoring today's webinar. And before introducing today's speaker, we have a short message from AccuTitle.
We at AccuTitle offer title management platforms to empower title professionals to close with confidence. Our house consists of brands you may already know: Closer's Choice, LandTech, Tracker Pro, and Title Fusion, AccuTitle's cloud-based platform. We offer solutions to make the intricate real estate closing process more manageable. We combine the vast integration network developed by Closer's Choice with the renowned title experts from LandTech and the end-to-end title production and accounting package of Tracker Pro. Together, paired with the highly customizable solution offered by Title Fusion, we are confident we have the right technology for you. All of our platforms offer a streamlined experience with robust capabilities and integrations. Partner with us today and close with confidence.
All right, thank you, AccuTitle. Move some things right here on my screen, show the presentation again. There we go. All right. Now let me introduce today's speaker. Joining us today, we have Monica Gilroy. Monica is a real estate trial attorney, which she's been for 30 years. She's managing member of the Gilroy firm based in Atlanta, Georgia. She regularly assists title companies, closing attorneys, real estate agents, property managers, and real estate brokers, when there are title or any other contract issues when they may arise. And she's an active member of ALTA. Monica has served for the last 2 years as chair of the association's Title Action Network, which helps us ensure there's advocacy for the title industry across the country. She also serves on ALTA's Title Council Work Group, the Education and Public Affairs Steering Committees. Monica, thank you for advocating for the title industry and constantly helping our members and offering this presentation today.
Well, thank you, Jeremy. Great to be here today. Big thanks to ALTA. Love always being able to be together with all of our ALTA friends and family. As Jeremy mentioned, I have had the honor of serving as the Title Action Network, or TAN chair, for the last 2 years, and we'll hopefully embark on that again for another year. But I want to take this opportunity, as I do whenever you get to see me, to pick up your phone, because it's so important to be sure you're an active member of TAN, all signed up for our various alerts that come across in terms of legislation on the state or federal level that affects our title industry. And so just to be sure, I always want you to be able to write down this information for me, and if you'll do it when we're done, I'll appreciate it. I want you to write down the letters T-A-N, TAN, which you're going to text those letters, T-A-N, to 52886. Text T-A-N to 52886 on your phone and follow the prompts. That will help you to become registered as a member of TAN and to receive our various alerts when they occur. And it's, again, we have to be the voice for our industry. We know it best. No voice, no vote. We don't get to be able to make the changes that need to be made and ensure everything works the way it works. So there's my selfish first.
put that in the chat box too. So if anyone wants
Oh,
to.
Thank you. Yeah, perfect. Thank you, Jeremy. That's wonderful. So I appreciate it. That was my selfless plug. Okay, well, first of all, thanks everybody for being here today. Hopefully you're going to have some coffee, lunch, or after lunch with us. Well, we talk about something that I'm sure if you haven't experienced already, you're going to. What basically happens, what do I do now? I've gotten a subpoena. What do I do? So our agenda today is going to cover kind of a high-level review of all of this or information about this, as well as give out some tips and tricks. We're going to start with this agenda right here, as you see, of what is a subpoena, types of subpoenas, and backing up a couple steps. When we have litigation of any type, right? There's a time in litigation that's called the discovery time period. This is what is really just the fact-finding period during a lawsuit or during a criminal action if there's a criminal case that's pending against someone. We don't live in a world of the movies and TV. Surprise witnesses don't burst open the doors at a courtroom and come walking in, and documents don't magically show up. Things are produced by the two parties between themselves, so that everyone knows and has an even playing field. And as part of that discovery process, oftentimes subpoenas are used to obtain information from third parties, people who are not the husband and wife who are suing each other for divorce, or the creditor, the bank that's suing a fraudster, or the government suing a fraudster for something that's happened in a crime, or it's something that involves a real estate transaction. So a subpoena is the mechanism, the legal mechanism to obtain third-party information, or to obtain information that a party to that action may have, but may not have completely, or to ensure you have the most verifiable and accurate source. So if one of the people being sued in the case or involved in the case actually participated in the closing, let's say it was your buyer, right? Well, your buyer probably got a copy of everything, but the subpoena would be used to ensure that the person who wants it or needs it is getting it from the actual source, the original source, which would be you, the title agent. So that's the concept of, when we're talking about subpoenas, why is it important to understand this? We're also going to talk about what do you do? So, I don't want you to panic. I'm going to give you some tips as to what do you do if you obtain a subpoena. We're going to talk about what you can and can't provide. And again, some tips and takeaways. I always encourage you to, anytime I get the chance to speak and teach to my ALTA family, to be sure you're training your staff. Let them watch this too, or hopefully they're there with you, you're all watching it together, because it's great that you may know it as the owner or the senior person within your operation, but your staff needs to know all of this too. And by empowering the staff, you're preventing so much liability potentially for yourself, because everyone will understand. Then, as Jeremy said, we should have time at the end, and we'll leave time purposely for questions to be sure that we can answer anything you want to know about subpoenas, or even just litigation in general. You've got me on the horn for as long as you need me to answer any questions you have about that. All right, let's move to the next slide, please. All right, let's start first with what is a subpoena. And just the basic definition is, as you see on your screen here, it's a court-ordered demand that a person appear in court or other legal proceedings, and we'll talk about that in a minute. It'll talk about specific documents that may need to be produced and presented at a specific date, time, and location. Subpoena is just a Latin term, means under penalty, and that's because if you don't adhere to it or answer it, usually we say we respond to a subpoena or we answer a subpoena, you are possibly subjecting yourself to criminal or civil penalties. What does that mean, Monica? Well, it means if you're subpoenaed to produce documents, let's say in a divorce proceeding, right, which would be a civil proceeding, the court can sanction you for not producing those documents. They could assess attorney's fees for the other side. And if the judge gets really mad, he could hold you in contempt of court. So that's why subpoenas are very, very serious. Now, a subpoena is going to be a piece of paper, right? It's going to be a piece of paper, and it's most likely going to be served on you personally. It'll probably become with somebody coming to, serve you, or if you have a registered agent. It is possible it could be served via mail or electronically. Again, this is a national conversation we're having, so obviously every state is a little bit different. In most states, attorneys also have the ability to issue a subpoena. So an attorney, right, like me, I'm an officer of the court. And so I can go to pretty much any court across the country that I practice in, and they will have their own subpoenas, their own documents, right, that literally I can fill in, print out, sign as an officer of the court with my bar number that has the same legal effect as if I went to the clerk of court's office, got the clerk to sign it on behalf of the judge with a big old fancy seal. Now, because I'm old, back in the day, we didn't have things online, right? That's the only way you'd get subpoenas is you'd walk across the street, you'd go and you'd grab a big stack of subpoenas that you'd have in your office that the clerk would then have to go and sign. But we've moved away from that. Let's move to our next slide, please. So when we're talking about what's a subpoena, the issue of who can issue them, right? It can be issued by any federal or state court. And again, depending on your state, you're probably going to have a lot of different courts within your state. Here in Georgia, where I'm physically located, although our practice is a national one, we have a variety of different courts where a subpoena could come from. But subpoenas can also come from like state boards. For example, a real estate commission or a Department of Licensing might request this. Let's say a real estate agent is being brought up on charges by their state's Department of Licensing or their real estate commission. Let's say it's in Texas, right? The TREC, right? Something like that, Texas Real Estate Commission. That commission may issue a subpoena to a closing agent because they may need information about a transaction that agent was involved in. You may also see it in federal departments like the IRS, right? That's probably the most common, right? The IRS may ask for a file, they may ask for information, obviously, the most common types of cases that you can see that a title agent would be involved in, probably the number one would be a divorce, right? Usually there's something that's gone down between whoever's kept the house, or maybe they're supposed to sell the house or refinance it. But usually a divorce is the most common type of case that you'll see a subpoena issued to a title agent. Obviously in title litigation, which is what I do all day long, right? If somebody's, if we have contesting chains of title, or if we're trying to do a title clearance, obviously I always try first as a trial attorney, I always try first to reach out to the person that I need their file from. Subpoenas are a little aggressive, right? They're a little in your face. You always try to take the high road and be polite and say, hey, I have this matter. But we're going to talk about also the importance of maybe you need a subpoena to give information out. Maybe even though I'm your buddy and your pal and we have lunch every week, maybe you don't want to just hand Monica over your file. You'd rather have Monica send you a subpoena, and then you have that subpoena in your file to protect you. And we'll talk about that more in a little bit. Another type of case we might see subpoenas being issued in is a creditor's right dispute. Somebody's challenging, say, a foreclosure or an eviction, or it might be a lending action. They might want to know what type of information was provided at the closing or not provided. Obviously, when we have fraud, that is a very common situation. Years ago, we had files that were subpoenaed by a federal prosecutor because a big mortgage fraudster was being prosecuted, and he had done these deals up here, then we had done deals that were clean that were over here, and so we had to come to court. My partner had to come to court and actually testify about our files to show how the money had transferred and what had happened, right? We hadn't done anything wrong, but we were involved because we had some small tangential aspect of that case that we needed to tell the public about. And then obviously financial crimes, like I was just talking about, that's probably another big one. Especially these days, we have so much, money laundering and terrible things that go on. So that's a very common area where you may see your file being subpoenaed as well. Let's go to the next slide. Here's what kind of an example of one might look like. This isn't what they all look like, but I can pretty much share with you that the word subpoena is going to be on there somewhere, right? And it's probably going to say at least somewhere you are commanded. It's going to have language about, to whom it's addressed. It's going to tell you what is needed. It may have some sort of seal on it, but it's definitely going to look pretty fancy, even the ones that are issued by lawyers. Again, depending on whether it's a state court, a federal court, or some sort of state or federal agency, it may look different, but you can pretty much be guaranteed it's actually a subpoena when you see that word right on there. Let's go to the next slide. Let's talk about now what types of subpoenas are out there. And here's where all the fancy Latin words come in. So there's basically two major types of subpoena. One's for witnesses, which are called subpoena et testificandum, and that is going to be a legal document ordering somebody to appear to testify, right? I am subpoenaing Jeremy to come and testify in this case because he was there when the car hit the other car and he was a bystander, right? He saw it, he knew it, he has information, right? Versus a document subpoena, which is called a subpoena ducis tecum, and that's probably the most common way a closing agent's file is going to be subpoenaed, is because they want the documents, right? And that's going to be a subpoena ducis tecum for documents is going to be just that, the subpoena legal document ordering the submission of the documents as evidence. Now, sometimes people will think, oh, good, I just have to put in my documents just walk into the court by themselves. No, unfortunately, if it is even a document subpoena, it will require 99% of the time a live person to bring that file in, say that this is a file kept in the regular course of business, that this is all accurate, that they're the custodian of those records, and then the records come in from there, right? And the records speak for themselves. The reason why we have to do that is, of course, if we are lawyers or if we are fans of legal crimes, that concept of hearsay, the concept of things that are admissions or spoken statements, I should say, that are made outside of the context of the court, in order to ensure that the documents are being accurate and valid, we have to have an ability to have someone say, yes, this is actually my closing file, and that's what we need. You sometimes will also see subpoenas for deposition. A deposition, again, is part of that discovery process in a lawsuit. A deposition is a sworn statement given under oath. It is not unusual in especially highly contested litigation for depositions to be requested. It's a way for the lawyers to understand sort of what's going on. And so you and your file may be invited to come in and give this deposition where you're talking about your file or talking about the closing or the work that you did. And then, of course, there's a grand jury subpoena, and that's for both the federal or state level. I would say almost 100% of the time, you're going to know that that's coming, right? A grand jury subpoena doesn't just show up at your door unannounced. That would be pretty scary, but those are other types of subpoenas that are there. And when it comes to a deposition subpoena, you probably know that that's coming as well. Now, you may not know, though, if a subpoena to testify or a document subpoena are coming. They may just show up in your mail one day, and that's why hopefully this class will give some, or this discussion will give some tips as to what to do if that happens. All right, let's go to the next slide, please. All right, so let's start first with what do I do, right? Obviously, the first thing I want you to do is not ignore it, right? Do not ignore the subpoena. First of all, don't freak out. It's just part of doing business, right? But do not ignore it. I do not want you to just pay no attention to it. I want you to read it, all right? And what I want you to do when you're reading it is to understand it. And I want you to go back and think about the W's, right? I want you to be thinking, as you're not ignoring it and reading it and understanding, who is this from, right? Who does it relate to? Like, what client is it? Who is this about? What is it about? What kind of case is it? What did you do? What did you do, but what did you do? And why are they asking you for this? And then what do you know and what do you have? So your initial review of this should always be thinking of the W's in terms of who, what, why am I being asked for this? And then, of course, more importantly, when, right? When is something due? When is something that I need to do about? So once you've done that and you've read it and you've understood it, and I would also give as a side practice tip, be sure in your office you have an escalation policy for a subpoena. A subpoena should be treated just like being served with a lawsuit, okay? It shouldn't go and sit on, the person who sits by the front door's desk. This needs to go right to the top because there's liability for your company associated with the failure to answer it, and it's a very serious thing because it's a court telling you to give something to someone. So you want to be sure that it's always, you have an escalation policies for subpoenas, all right? So depending on the nature of it, there are times when you may need to reach out to your underwriter or even to your attorney, simply because as you're reading it and understanding it, if you're thinking, wait a minute, why are they asking me this? And you're getting a sense of, wait, do they think I did something wrong? right? Or am I being asked for this because there's a chance for a claim to be made down the road by an underwriter? Depending on the nature of it, you may, in that early initial stage of getting it, want to reach out to your underwriter or even to your attorney prior to responding. And remember, it's always a good idea in general that if you have any doubt about anything that hits your desk, call your underwriter. They are your friends. That is what they are there for. They want you to call. No question is a dumb question. No question is a silly question. They want you to be discussing things with them because they would much rather know now, right, than find out later. The reason why we as title agents can have problems in our practices and in our businesses is when we don't share that something has occurred, right? So never be afraid if you get a subpoena. If it looks like it's something your underwriter should know, let them know. Let them be the one that say to you, oh, geez, I don't need to know about that. Just you take care of it, okay? The other most important thing I want you to do if you ever get one is absolutely look at when, the W of when it is due, all right? Very, very important to know when is it due, when do you perhaps have to appear in court or at a deposition, and I want you to calendar that. And I don't want you to just calendar it one way. I want you to calendar it 2 or 3 ways. I want you to put it, if you're, old like me and maybe still have a paper calendar, I want you to put it there. Definitely want it in your electronic calendar, put it in your phone, and then someone else in the office, anybody, right? And if you're a one-person operation, tell somebody you know, whatever you need to do, put it on your home calendar, but be sure that that date is very highlighted and circled within your calendaring systems, because again, you don't want to miss whenever that information is due, because that could create liability and penalties for you. Then, once you've done all that, then you're going to begin the process of gathering the documents, all right? And this is what we're going to talk about in a lot more in depth as we proceed today, but you have to read again very carefully, what are they asking for? Because lawyers, especially litigators, love to use words like communications. Now, communications used to mean talking to each other, right? Well, we know for decades that it's not been the case, right? Communications is going to be not old-fashioned letters and documents, and it's not just going to be emails. It could be text. It could be social media posts. It could be, I had a case once where we kept asking, have you ever communicated with so-and-so? And we went through all these things because we, all these platforms. We said, have you ever, spoken on the phone, communicated by email, communicated in text? And somehow or another, the lawyer said to ask, have you ever communicated on WhatsApp? Well, yes, he said. So of course, we all threw back our hands like, oh my gosh, we didn't think to ask about all these social media sites or all these other methods of communication. So that's why when we begin gathering, we have to really think very broadly as to, okay, what would that mean and what would we do? But also it's important to understand, what is the person asking it for potentially mean? What are they looking to get from us? Let's go to the next slide, please. Okay, what can or can't I provide? This is where you need to take off your transactional hat, okay, and put on your litigation hat. And thinking like a litigator means assuming there's something, I don't want to say nefarious, but assuming there could be something up with this request, right? I want you to think, why do they really want this? Now, it could be the most basic of reasons, right? It could be a divorce action where wife sold the property and they're fighting about how much husband was supposed to get, right? Meaning you didn't do anything wrong, you just closed the deal. But I want you to always be thinking like, wait a minute, is there any reason why this is being asked that could come back to bite me, right? Why do they want this, right? What is going on? And that leads to the concept of, we have in our closing files a lot, if you think about it, right, of confidential and private information, correct? We have on the closing disclosures, we have on all of the initial documents that come in, right? We have social security numbers, we can see bank accounts, we can see birth dates, we can see amounts of money, we can see things that other people can't see. And so we need to always be thinking about, well, okay, if I have to turn over my file, is there anything that's private in here? And that goes back to what is being asked and the why. What are they fighting about, or what is the underlying dispute, right? The other thing is, depending on if you're an attorney closing state, do you have any attorney-client privileges, right? Is there anything between who is your client? We're going to talk about that in a more in-depth in just a couple of slides. But thinking always about, well, wait a minute, do I as an attorney, have I represented any party in this transaction? Maybe my client happens to be the realtor under the laws of your state, right? Do I have any communications that are privileged, meaning not legally required to be produced, right? The same goes for maybe you as the title agent reached out to your own attorney at some point during the process. Going back to this idea of thinking like a litigator, what if you reached out when you got the subpoena and were like, I'm a little nervous about this. Why does Bank of America want this? Why are they asking me for this? And you go and consult with your own attorney, and then you put that communication, that email, into that file. Well, that would be a communication that is privileged between you and your counsel, and that would not be something, right, that you would want to produce, that you should not produce something that could have a privilege, a legal privilege attached to it. This is important because, again, in both our attorney states, but just really in general, when you're thinking about any time a lawyer may be involved from the closing side, who is that client, right? Who is it that I may owe any duties to? Do I owe any duties in my state to the communications I have with any parties, unless they're who are not actually my clients if I'm not a lawyer? I will say, though, in most of the country, a title agent is not going to have any privilege or any protection from communications that they have with the realtor or with the lender or with the surveyor. So let's pretend the dispute is a boundary line dispute, right? And let's say when your file came, you actually reviewed the survey. Let's say that there was a survey, the lender wanted a survey, and you reviewed it. And in your review, you saw that seller's property line is a solid 5 feet over, right? Their fence is a solid 5 feet over into the neighbor's yard, right? Well, if you knew that and you didn't tell the buyer that, what kind of obligations does that create to you, right? What if you called the surveyor and you said, look, I think you're wrong. I think it's actually 8 feet over, not 5 feet over. And that all ends up in your file. What about if you're talking to the realtor and you say, let's say it's a failure to disclose case. Let's say that there's some sort of problem with the house, right? And what if in the context of the closing, you've had communications with the realtor, they're asking for, say, like a termite bond. Well, that's a very southern referral, but something having to do with bugs or insects, right? Let's do rodents, let's say rats, right? Rats in the attic, bats in the attic, whatever, pick what you want. And let's say that, you as part of the closing are paying off an exterminator bill, and you talk to the realtor, and the realtor says, oh my gosh, this house has the most disgusting rodent problem. And you're like, oh yeah, that's awful. And you may have knowledge of that. And yet, what if that realtor doesn't communicate it? What if the seller doesn't communicate that problem? Suddenly you may have knowledge, right, that someone else in the transaction didn't have that may end up in your file, but that's probably not private and it's probably not privileged. So we're going to talk in a minute about just little tips and tricks about when you're communicating with people like realtors, lenders, surveyors, being careful about what we say and comment on to make its way back into a file. The other thing that happens when you get a subpoena is the concept of redaction. And I tried to look today on my messy desk for just a good old Sharpie, because years ago I had a young lawyer here in my office, and I said, I need you to redact this stack of loan documents taking off the Social Security number. And they didn't know what I was talking about. And all I'm talking about is taking, I don't have a Sharpie anywhere, but let's pretend it's a Sharpie. Taking your black Sharpie, right? Literally taking the document that may have the full Social Security number on it and blacking out, right? Striking out everything but the last 4 of that social, right? That is what redaction is. Taking out, not completely drawing a line across it, because then nobody knows what you crossed out, but maybe crossing out the first 5 numbers of a bank account, right? Something where the account could still be identified, but not actually be fully out there, right? Be very cognizant when you're responding to a subpoena about providing confidential information, especially confidential financial information, Social Security numbers, things of that nature. I would say my advice would be err on the side of caution. And if you're producing your file, I'd rather see you make a photocopy, right? However you want to do it. Some people like to make a copy, redact, make a copy. There are also many, many electronic redaction programs. That's what we use here at my office. Once I still like my marker, but everyone else in my office uses the electronic redaction. But you know, that is something that's very important. I would err on the side of caution, even if you're being asked by even if one of the parties to this suit was the person that closed the deal in your office, I would still not give out the full Social Security numbers, the full bank numbers, credit card numbers. I would just take that redaction tool and do that. Rather that they come back and the lawyer says, listen, I need an unredacted copy, and you can cover yourself and you can say, okay, I'll give that to you, but I want to be sure you are keeping that confidential and private, right? Better not to just ever, never, ever, ever, if you take nothing else away, never just blindly produce your file without some kind of scrub or review to see what's there. That's what we do as litigators. We look through everything to be sure that there's not a privileged communication or any kind of confidential financial or Social Security numbers that could come back. I'd also urge some caution to remember the context of the case. What if this is a highly contested divorce, right? And usually, you know, even though you may not know everything about a lawsuit when the subpoena comes, common sense is going to dictate if you see husband versus wife or wife versus husband, you know, maybe there's something else going on there, right? You don't know, right? So because of that, be cognizant too of addresses, full addresses, phone numbers, emails, things like that. Now, I'm not suggesting that you redact every single email address, but I'm suggesting if there's information in your file that maybe says where the seller moved to, right? Let's say it's the seller's forwarding information. Maybe you redact some of that, right? If it's in the context of a domestic situation, because what if that would lead then to somebody taking that, finding that person something bad happening, right? You're unwittingly conveying information that truly, you know, could be public, but actually in this context could be private. So just always giving it, again, a little bit of a thought, a little bit of a mental massage in terms of, okay, what is this really about? And that again goes back to the importance of when you're reading the subpoena, if you have any questions at all, pick up the phone and call the person who sent it to you and say, what is this about? You know, hi, this is Monica, the title agent. You're asking me for my closing file on 123 Main Street. It looks like this is a divorce between the seller, you know, and again, it's public record. Lawsuits are public record. Now, you may not get as much information from a government agency, the IRS, the feds, you know, in an investigation, criminal investigation. But in a basic old civil context, civil lawsuit, the lawyer has filed something. There's a lawsuit pending, and that's public record. And they should be able to tell you at least basic information. What is this case about? And don't even hesitate to say, let's say it's the context of the divorce, and your seller is part of that. Look, you know, it's got her forwarding address or his forwarding address in there. Do you want me to include that? I'm happy to redact that. You know, get some guidance from the person asking for that information. And then the number one rule that I have in everything that you should do in your life, document that, right? So if you've got a subpoena, you're calling, you're taking that due diligence to find out what is it about, what's going on, what do you want me to do, what do you not want me to do. Then it could be a self-serving, dear Mr. Lawyer email, thank you for speaking with me, or just make a note to your file, put it into your email communications, make a record of conversation somewhere, just to prove that contemporaneously this is what you did, right? It's always better to have that so you don't have to rely on your fading memory, or just to show that at that moment in time, that's what you did, and that's why it was important from that perspective. But be very cognizant of, am I giving out private information? Am I giving out privileged information, right? And then if I have to do any redaction, just being a little sensitive to what kind of information you have in your file, because we do have some very, very sensitive financial information as well as Social Security numbers and the like of that. Let's move to the next slide. Okay. What can or can't I provide? And that kind of leads us to the question of, usually you're going to be being asked for your closing file. Well, what's in my closing file, right? Let's think about what's in your closing file. There's going to be obviously the title and then your notes about the title. And again, depending on how you do it, or your abstract, depending on your state. But you know, you're probably going to have somewhere some kind of notation, right? I think it's highly unlikely, and whether that's you print it out and it's in pen, or whether it's electronic, there's probably some sort of analysis, right? Some sort of analytics that has been placed on the title. Even if it's just as simple as a check mark of, okay, this lien was released, this lien was released, whatever. those are still mental impressions. Those are still things that you have made, notes you have made as the title professional in analyzing the title that you've seen, right? So it's very important when you're looking at your file to look critically as to, going back to the W's, well, what did I do, right? Yes, I ordered this title, or I searched this title or this abstract. Yes, I reviewed it, I analyzed it, but, you know, what did I do? Did I, you know, lay anything out? Did I make notes? Look at all of that, read it, right? You're also obviously going to have in your file all of the closing documents, right? So if it's a cash transaction, you'll have your HUD and all the other accompanying documents. You'll have your CD and your LE in a funded transaction. But remember, if you're dealing with a funded transaction, then you're going to have, again, like we just shared, probably the LE, probably other information, maybe about open credit cards or other things that might be there, you know, that could be financially sensitive. Now, you may have, as we see oftentimes, and this may take us out of the context of a divorce, let's take it into a title claim litigation case, right? You may have memos that talk about maybe even the mistake that's being litigated, right? This is something that we have to be very, very cognizant about. And so, yes, it is very important, obviously, to answer a subpoena truthfully and honestly, but you do have the ability to look and see, well, okay, what's actually in my file? And I'm not suggesting to hold anything or not do it, but if you've got something in the file that says, gosh, I really, you know, we need to get a copy of the release of that lien. Now, I called the lien holder and he told me that it had been paid and that he was going to cancel it. So I can, you know, I'm going to write a note, talk to him, relied on his conversation. Well, what if it turns out he never did it? What if it turns out it was never released, right? That information that's in there, you know, could potentially be something that isn't so hot, right? Sometimes post-closing, we realize a mistake has been made. We make a memo, we stick it in the closing file. Maybe that's not the best place where we should put memos of where we may have discovered a post-closing error or concern, right? Perhaps that should go somewhere different, correct? So depending on where the subpoena, what the subpoena says, that may or not be something that you have to produce. Again, I'm not advocating for not being honest, but just don't assume everything should live in your closing file, because that is what's going to be most likely requested, and maybe not everything needs to be in there. When you're looking in your closing file, what about, as one of my favorite paralegals used to call them, snarky emails, right? What if you're having an inter-office communication and you're like, oh, that agent is the worst, or, you know, I've seen some where there's not very nice names being called, right, of each other, or complaining or saying things or talking about shortcuts, right? Just be cognizant that if that's in your closing file, those types of communications, most likely that's something that's going right out the door with that file. You want to be careful, obviously, always when we're communicating and it's going to end up in a closing file. The communications are always professional, not with commentary, right? Not with any sort of colorful descriptions of what's happening, but keeping it just the facts, very straight and professional. Because again, if you produce that file, there, you know, could be a very unprofessional email that's in there or communication that's in there that later becomes something that, you know, a lot of people are going to see. So you got to think about that. You also need to think about any other internal notes that are in there. And again, maybe those internal notes, that's not where they're supposed to be, right? Maybe that's not the best place, some sort of internal note, you know, paralegal was out sick for 2 weeks with COVID, only, was supposed to do the final title check down and didn't, right? Maybe that's not where that's supposed to be, right? Maybe we just need to have in our file the title we did and the title check down, and let those dates speak for themselves. Maybe we don't need to be blah, blah, telling all this stuff that's going on in the inner workings of our office in our closing file, right? Because what you can produce is going to be subject to the previous slide, right? Whether or not it's privileged or whether or not it's produced, but with any sort of redaction to it. Because pretty much if it's in there, you're going to have to provide it, right? If it's in that file, it's there. That leads me to the next thing that might be in your file, which are checks. Very common. If you're working out of any of the different platforms that are out there, your checks are going to be part of that closing file. I would not recommend at all sending copies of your checks, your checking accounts, right? Unless you've redacted, because we know that is a rampant form of fraud across the entire country, where people are taking just even snapshots of checks, reproducing them. using the routing numbers. So do not send your own check information, your escrow account information, your checking account information. Do not send any of your checks out unless you have redacted that. And I'd actually, I'd redact the whole darn thing. I'd do anything to be sure that if the check is in my file and it's going out, that nobody could copy it, draw an X through it, whatever you need to do. But give thought when your subpoena comes in hand and they say, I want your closing file. That's usually what it's going to say, right? Produce the closing file for 310 Green Avenue, Milwaukee, Wisconsin, right? And in that file is going to be a lot of stuff. And because the subpoena is such a broad net being cast, pretty much everything that's in your file has to go. So give some thought internally as a practitioner and as a title agent as to what should be in your file. That's why I'm making these comments about notes of mistakes, memos of mistakes, snarky emails. Here's another one, communications with your underwriter, right? Not privileged, but more of a business function, correct? Maybe if you're communicating with your underwriter about this file, depending on the nature of what the case is, maybe that communication should not be actually in what's considered the closing file. So again, I'm not suggesting pick and choose. I'm not suggesting not truthful disclosure. I'm telling you and suggesting that maybe we have to think about what a closing file means as opposed to business records, things done in the course of our business, right? That's maybe not where an internal note needs to go. It's maybe where, again, we need to be careful if we're emailing, just of what we're saying, things of that nature, all right? Now, for my friends in the title attorney states like here in Georgia and across a lot of the platforms that we have ALTA members in, is the title exam itself, just the exam in the notes, right? Is that privileged in our attorney closing states? I take personally the position because in Georgia, in a funded transaction, I am the attorney who represents the lender. The lender under the Georgia law is my client to whom I own privileges and duties, right? So oftentimes, depending on the nature of the case, I will take the position that the title and the title notes, even though the title is public record, right? But my examination, my interpretation of the title records, that's privileged, that's something I did on behalf of my lender, right? Now, in Georgia, we'll take Georgia as an example. In my state, if there isn't a financer involved, no lender, then I really don't represent either buyer or seller unless my contract designates, okay, you represent buyer, you represent lender. But even in my state, the laws of who is your client, a lot of it is, was there advice requested and was there advice given, right? So it can get very, very gray. But that's another reason why if you get a request for a file request and you're in an attorney state and you are not a litigator, don't take up the time to become one and play one on TV, right? Call me, your friend, your friendly litigator, right? Call Monica, call whatever, your buddy, call your underwriter if you're not sure, but be sure you understand in your attorney closing state who is your client and what type of information can and cannot be given out, because that's very, very, very important. We want to be sure that you're not, unwittingly violating anything. So what I really want you to be thinking about when that request comes is just, okay, what's in my file? And maybe, I know we're all so busy, but take a minute perhaps after this discussion we're having today and just pull a file. Look at the last file you closed. See what's in there, right? Is there anything in there that if you had to later go back and explain that file and you're like, boy, I wish that wasn't in there, right? Maybe I shouldn't have detailed, the reprimanding process of the paralegal and stuck it in that closing file, right? That shouldn't be there, right? That kind of stuff shouldn't be there, right? Why is that there? Why is there some internal note about, oh, I hate that title examination company that we use. They always miss stuff. Why is that there? It shouldn't be there, right? Have an eye on what is part of a closing and what is your business? What is the operations of your business? Because that, again, that's not dishonest, it's not bad. It's just being sensitive, right, to where certain information should be. Trust me, if somebody thinks you've done something wrong and they want to get all these other things we're talking about that are your internal business documents, they can get them, right? It's not like they're never going to see them, but why would our files contain anything other than exactly what we did, right? Being conscientious of any privileges we may hold to someone and any private information that we're giving out, all right? Okay, let's talk a little bit and wrap up, and then we can take some questions or talk about literally anything you want. So some tips and takeaways. Absolutely do not be an ostrich. It won't go away. And this is true, friends, not just of subpoenas, but of lawsuits, of complaints, of angry customers. You know, things get out of hand and become litigious when people don't give things the attention that they should, right? It's important to somebody. It may not, it may be ridiculous. You might be like, that person is off their rocker. But if they were upset enough to reach out, take some sort of action, don't be an ostrich, because it probably is not going away. And in the case of a subpoena, it absolutely is not going away. Because remember, even though Monica, the lawyer, may issue it, I'm issuing it as an officer of the court. It is a court or a governing body or authority telling you that you need to get some information that you have in your possession into the hands of someone else, all right? Now, do not panic, do not be afraid, and do not feel that you immediately have to lawyer up. One of the beauties of ALTA is that there's so many of us who practice in areas that complement the closing arena. You know, in my office, yes, we have, closing work that goes on, but we obviously have the primary work we do here is real estate litigation and civil litigation. So, we're all very well versed, as are probably many of your colleagues across your state and your friends, as to what to do, right? So don't panic. Reach out to someone you know. Do not feel that you immediately have to get a lawyer. The caveat on that one would be, friends, anything that comes from the feds, it's just a little more scary. Like any sort of, obviously, if it's a grand jury subpoena, please, yes, consult an attorney. But the federal courts are a little more serious, right? Those are just big kid courts. So that one, maybe have your antennas up a little bit. At a minimum, reach out to whoever sent it to you and say, what is this? What is going on? And you have a right to ask in the federal context, am I a focus of any of this action? Like, especially if it's a criminal action, you have an absolute right to say, is my company or me the focus of anything you are doing? They have to answer that. So that's again where don't panic, but don't be afraid to ask. Don't just blindly hand things over, okay? Please train your staff. Have them take a chance maybe to sit, maybe bring in a pizza. Pizza goes a long way, or if you're all working remotely, send them a $15 Uber Eats gift card and have everyone watch this. Please be sure that they're watching videos, training videos, to be sure that their files are clean. It's all top down, right? If your staff knows what you know, then you are going to have a flawless operation. But you've got to be sure your staff understands that even though they may absolutely loathe that loan officer and it's the worst person they've ever met, please do not call them, the horrible Larry the loan officer in the emails or whatever, even as a joke, or put things like, thank goodness, this loan is closed. Just be sure that they're being cognizant that there's no reason to have any of that in the closing files to keep those files clean. Although we love, as a marketing tool, social media posts, I closed here, I closed that, they did that. Just be always very cognizant of your social media posts, because they are, across any place we have here in the United States, they're communications, right? Now, they may be a communication by me to the entire world or all of my people in my social network, but they're still communications. So again, highly unlikely that there would be some sort of negative post, but if you're posting pictures of somebody that closed, and it was maybe, think of the divorce context again, maybe they don't want that. I'm sure you're always asking people before you're taking their pictures and posting, is this okay? But just don't forget that the social media post in any platform is absolutely a communication and absolutely something that's coming from your office, going outward. When in doubt, obviously, absolutely ask for help, like we've talked about. You can always call me. I'm a friend in the industry. My email information will be up in a minute. And then finally, keep a copy of what you send. Keep it electronically. Keep it, if you redact it, a clean copy, unredacted, and the redacted copy, right? Have proof that you did what you were supposed to do. If the subpoena says overnight it by this date to my office, then be sure you have proof you overnight it by that date to the office. Call, follow up, be sure that the person obtained it that requested it. If in fact you have to go to court, be sure when you are done, you say to the person, is this it? Do you need anything else from me? But you want to always be sure you have followed it through from the minute it was served on you to the minute you concluded doing what you needed to do. And keeping a copy is just a great way to be able to prove later on if something happened, what you did and did not do. So with that, it looks like by my clock, we've got about 9 minutes maybe. Does anyone have any questions? I think, Jeremy, do they ask some of you in the chat? Is that how it works?
Hey, Monica. Yeah. We have gotten several questions.
Oh, good.
Just a reminder, if you have any questions for Monica, get them in there and I'll pitch them over to her.
Awesome.
A lot of the questions, Monica, you probably know this, center around, what do I have to provide? What is can be subpoenaed. So we'll run through some of these. I'm pretty sure you did touch on a few. Rose asked about run sheets. I'm not sure what a run sheet is. She said run sheets are licensed and not shareable. Does a subpoena trump any licensing? Currently, she excludes those from any subpoena requests.
That's a good idea. Yeah, run sheet meaning something that is going to be just that, running the initial title. I was in my mind, I was speaking of today like a title note. Yeah, the fact that something might be licensed by somebody else, my general thought would be, if it's in your file, you got to produce it. Now, if you're not producing it, Rose, what I would do is maybe stick just a simple note in the file, or when you send it back, say, I am not producing. It's always good to tell them what you're not producing. I am not producing the run sheet. I view this as being licensed, and I view this, it's my custom and practice not to produce them, right? I tell people if I haven't produced something for a reason, right? So I do think generally if it's in your file, it should be produced, but I understand your rationale in not producing it. Similar to the discussion we had about is it privileged if you have an attorney-client privilege?
Is that how the subpoena is worded? Like your file is being requested?
It's going to be so broad. It's going to be like, think of like, literally we were just doing some here in the office for a trial for next week. And it's like any and all communications, emails, writings, regarding 123 Main Street. I mean, that is like everything you can think of, right? Lawyers rarely ask for very specific stuff. They usually want it as broad as possible. Go back to my example of asking the dude about, did he have any communications with this guy? And until we got to the WhatsApp, did he say, oh yeah, we talked on WhatsApp. So yeah, but usually it's very general. And that's why that goes back to be careful what's in your file. So if it's in your file, there could be an obligation to produce it.
Okay. I mean, obviously you want to be honest and ethical, but say you have these things that you've talked about in your file, can you go and remove them now? And
again, that's where you've got to be careful, right? I mean, that's where you have to do the W's. What is the nature of this? What are they looking for? If it's a divorce case where the wife never paid the husband the proceeds, right? Whether or not you thought, the realtor was a horrible person, probably could be taken out of the file, right? But if there's a communication there from the wife that says, do not give my husband any money, that needs to be in there, right? So you do have a little bit of self-censorship, but that's why those W's, that initial analysis, are very, very important as to why is something being requested, what is there, and my suggestion to keep certain information like personnel, or if something post-closing is discovered, don't stick that in the file, put that somewhere else.
Okay. All right. Another question on licensing or copyright. Brad says in many cases the land survey is not a public record and is copyrighted. So be careful to redact the entire survey from the file.
That's a really good one. Yeah, because surveys, right, are not. Yeah, that's a really good thing. And the survey may only be from one person or for one person. And let me say this too: couldn't the survey be gotten from the surveyor directly? Why do you have to be the one that shares that, right? You can. That's a very good point. You could certainly say, the surveyor's file can be obtained by writing him at this address. Yeah, that's a very good point.
A couple of questions on internal memos, and a little bit of a different spin. Tanya says, what do you suggest for memos that maybe shouldn't be in the file, but they work in a paperless environment using their title production software, and so they use the notes feature, for random stuff that others on their staff may need to know. So how would you suggest handling that?
Yeah, I mean, that's why I know we work in a paperless environment, but that's why when you have a subpoena, you're going to have to print it out, right? You're going to want to print it out. You're not going to want to just forward an electronic file. You're going to want to actually look at it in paper, triage it, scan it, And if in the concept of using your title production software, there is that note function, but the notes are going, say, to an HR issue or some other issue, I think you are justified in removing that, right? Because it's not part of the closing file, right? If it was a note reminding us that, again, like Sally's going to be out on maternity leave and somebody else should be, pulling the check down of title, that's an HR function. So that's why you should not ever be just popping an electronic copy of your file. Print it out. I know that is so unpopular these days, but print it out, touch the paper, redact what you need to redact. And if something really isn't supposed to be in there, I think you are justified in taking it out, subject to, again, then what is the nature of the suit, right? What is the nature of what's happening?
And I guess pretty much the same philosophy for any communication with your underwriter, right?
Oh yeah, I think depending on the nature of what you're doing, I think your underwriter communications, let me put it this way, in Monica's perfect world, I would prefer those not be in your closing file, but are in a separate file. Now, if it's all part of your title production software, print it out. I think those communications, right, can certainly be justifiably removed. But again, think of the context. If there's been some sort of title error that's occurred, right, and it's between, buyer and seller, but you're sort of, what you did at the closing caused the problem, okay, that's going to be a little different. That information should be then disclosed. It just depends, again, on the nature of it.
Okay. All right, we've got a few more minutes to go, a couple more questions to get through, right. But, if we don't get your question addressed, to your satisfaction, or if you have others, after the webinar, feel free to reach out to Monica. Her email and phone number is there on the screen. And
absolutely. I am always here for you all who are listening, and I'm so grateful that you're here. There's a lot of you here today, and I really, really appreciate you taking the time.
Yeah, Monica from George, his question is, if you're subpoenaed regarding a title claim, do they need to disclose that do they need to disclose that they're being subpoenaed to the buyer and seller?
Oh, that's a good question, actually. If it's a title claim and your file is being requested for that reason, probably the buyer or seller is the one requesting it. But that is a very good point, that there are times when there are some state laws in some states where people have to be informed that their information is being given out. So that's another reason of the W's, right? Who is asking for it, right? If it's not the people to whom you close this for, if it's a total third party, yes, I would err on the side of caution, regardless of your state law, right? But certainly if it is in your state law, be sure buyer and seller know, or whomever is in the transaction, hey, total third party over here is asking for this closing file. I'm not going to give anything out unless I have your permission, right? In some states, that's mandatory, right? But I would be very careful that if it's not somebody that's a party to the transaction, a true third party, I would definitely consider getting the permission of the players to your transaction before putting it out. And that's as simple to George's question of saying, well, is the buyer aware? Is the seller aware? By picking up that phone and asking the question of the person who sent you the subpoena. Okay.
All right, Michael, hopefully that answers your question too, because his was, if you receive a subpoena from party A, is there an obligation to notify party B that you've been
subpoenaed? Yeah, I would. I mean, again, there is always better, right? Always better to pick up the phone, err on the side of caution. Just be sure you say, look, I got this. Here's what I'm doing. Because truly, remember, a subpoena in essence is you're just a bystander. You haven't done anything wrong, right? That's the 99.9% of the time. So it's, yeah, always better to reach out and let the people who are being affected by that know if they're not part of the actual action that it's being subpoenaed for.
Okay. All right. We got two more in the queue, so maybe we'll try and knock those out, and then we'll wrap up. And this one from Mark, I'm not, and maybe he's serious, or maybe there's a little sarcasm. I think there might be some lawsuits out there about this already, though. But he asked if any answers to your questions were written with the assistance of ChatGPT. I'm not sure what that is. Mark, if you have a follow-up, send me a note and we can maybe address that offline. So
is that, I don't know if that's meaning like AI or something like that. A subpoena should not, let me just say this as a general thing, Mark. Subpoena shouldn't be asking questions, right? A subpoena is for documents, right? There isn't an avenue other than a deposition to get questions answered, right, by a third person, right? Third party discovery, that's what a subpoena is, right? That doesn't ask questions. That really just asks for documents. If they want to talk to you about something, then they should be bringing you in for a deposition. So if they say, produce any documents that were created by AI, then yeah, you'd have to actually do that if in fact you did it, if that's what that means.
Okay. All right. And you know, one question to wrap up, do any of the, you know, we're seeing more states pass comprehensive data privacy laws, and does that play into the privileged, you know, data that you have, that you can provide?
Big time. Yes. Excellent question. Absolutely. That goes back to the redaction. That goes back to you should always familiarize yourself with any kind of data privacy laws. But yes, there's obviously, I would argue as a title professional, there's obviously, I think, an obligation to be sure you are not purposely disseminating full socials, full bank accounts. I think that you should always assume that you're governed. Think of it as, what would you want someone to know about you, right? Would you want someone to know your full social? Would you want someone to know how much you made or how much what your bank account numbers were? You wouldn't. It's easy to still be compliant with the subpoena by simple redaction. And then if you have that extra layer of data privacy laws coming into your state or coming into your area, you know, being sure you're very familiar with them in case there's anything else that isn't allowed to be given out.
Awesome. Okay, we do have another question on more detail about privileged information, but Emmanuel, we'll work on getting an article put together for that and, you know, sharing, because that was actually pretty interesting, you know, that conversation, Monica, about privileged data.
Yeah.
Well, with that, you know, that we'll wrap up. If you missed parts of today's webinar or think others in your office would benefit from listening, a recording of the presentation will be available on our website, alta.org/webinars. And again, tomorrow you'll get an email with a link to the recording and a link to download a copy of the presentation. I do need to thank AccuTitle once again for sponsoring today's webinar. And that will bring us to the conclusion of today's presentation. Monica, thanks again for sharing your expertise on subpoenas. Hopefully everyone, you know, glean some good information, key things on how to respond, and don't be an ostrich. So.
That's right. And thanks again, Jeremy, to you and all the ALTA staff for all you do every day, and to everyone out there, again, thanks for the time to talk. Please feel free to reach out. I'm a friend in the industry, whatever you need.
Yeah. All right. Thank you, Monica. Take care, everyone.
Thank you. Bye-bye.